So it brings me great pleasure to introduce Hoy, who's been a friend. We went to law school together many moons ago at McGill. And we've seen each other's work over the years. We collaborated on a Cambridge handbook together. And I can honestly say Hoy is one of the leading professors of public law in Canada, is extremely kind with his students, was extremely kind with other students when we were students, and is recognized at his university for being a superb teacher. He's a full professor and inaugural holder of the Beverly McLaughlin Professorship in Constitutional Law, which he's assumed in 2018. And most importantly for today, he's Canada's appointment to the Venice Commission for Democracy Through Law. That means he is the national representative in a process of looking over practices in Europe and elsewhere for determining whether states are adhering to proper rule of law standards and constitutional standards. He's also a fellow of the Pierre Elliott Trudeau Foundation, or was until 20.
No, so
You still there? Okay,
yeah.
Right. Yes, it's not quite 2027 yet. And is the director of UBC's Centre for Asian Legal Studies. And he's been a longtime collaborator with Professor Ron Levy, another Canadian who is now has been for many years now, based in Australia. And they have a long-term project on deliberative governance and law. That's partly the reason why Hoy co-hosted a conference on deliberative constitutionalism here at UCL some 7-8 years ago, which led to the Cambridge handbook. So we'll be handing over to Hoy in a moment, and he'll be discussing how Canadian theorists have contributed to understanding the rule of law and some of the issues, constitutional rule of law issues that Canada is now facing. Before we get started, I wanted to say a word about the Sidney Seminars as a format. So they are named in the honor of a revolutionary thinker, Algernon Sidney, who was an advocate of rule of law principles and was opposed to monarchical absolutism. And his enduring legacy lies in his work, Discourses Concerning Government, where he challenged the divine right of kings. Now, Sidney has a connection to this group because in our inaugural retreat where we discussed the Global Centre, it was held in the historical ancestral home of Algernon Sidney. And it is after that thinker that this series is named. And it is in particular used to discuss really interesting current events in constitutional affairs. And it is for that reason that we're really looking forward to hearing what you have to say, Hoy. So welcome.
Great.
Looking forward to listening to it.
thank you so much. Thanks so much for the generous introduction. Thank you to Aaron and Chris for all the work that came into getting me here. I have an actually terrible sense of direction, so it's a minor miracle that I'm here. London almost confounds me. As Jeff said, I just took over the directorship of a research center, and having attended this the events and the lunch, I now have like a massive inferiority complex. So thank you all so much for being here. I know that it's a busy time of year, and I really appreciate your time. So in this presentation, I want to basically sketch out two things, right? So first, I want to talk about some Canadian theorists' contributions to the literature on the theory of the rule of law. Second, I'll sort of illustrate those theories to applications of issues that are kind of current in Canadian constitutional law. And although this is a presentation that's focused on a particular jurisdiction, I think especially the theoretical components, but also the application has implications for some of the broad questions that constitutional orders around the world are facing. So let me start with some of the contributions of some Canadian theorists to the theory and the literature on the rule of law. So basically, I'll isolate out sort of three kinds of contributions. Right? So first, there is a kind of methodological contribution, right? A way of thinking about theories of the rule of law, how to categorize theories of the rule of law. Second, there is a kind of, so if that's a kind of methodological contribution, there's also a kind of substantive contribution that theorists of Canadian theorists of the rule of law have made. And then third, in this sort of contribution of the theorists, I'll trace out some implications of these contributions to, I think, one of the abiding tensions in the rule of law literature between political power, right, the requirements of the exercise of political power, and the requirements of the rule of law. So those are the general contributions that I'd like to highlight of some Canadian theorists. So once I've sort of set out the theoretical background, I'll then move to two issues within Canadian constitutional law as a way of kind of illustrating these contributions, but also I think as kind of discussing what I think of as fundamental issues of constitutionalism and the rule of law. So the first issue I'll address as a question, as a sort of application of these theories, is the exercise of the emergency power. Right? And so for those of you who think about emergency powers, right, often thought that emergency powers are kind of outside of the constitutional. They act as an exception, right? And we'll see. Some people think that. I just got to really skeptical about. No, it's fine. No. It's good. But some people think, along Schmittian lines, that emergencies are sort of outside the requirements of the law. Yeah. And then a second kind of issue. Now I'm just going to look for you for a reaction. Is around section 33, or the notwithstanding clause of the Canadian Constitution. Right? And so the notwithstanding clause is an interesting, obviously an important topic within Canadian constitutional law, but it is also understood as a kind of important contribution to judicial review, right, around the world. So that's the general map, that's the general outline of what I'll be doing for the next 25 minutes or so. So let me start with the contributions of some Canadian theorists to the rule of law theory. Right? So first, there's a kind of methodological contribution. There's a way in which Mark Walters has kind of thought about theories of the rule of law that I haven't seen anywhere else, but that just might be my fault. But I think it's an interesting distinction. So Mark kind of distinguishes between rule of law theories that are essentially classificatory in their ambitions, right? And in the way they organize the theories of the rule of law, right? And so, for example, we have lots of checklists in the rule of law, right? So the Venice Commission has a checklist, but among rule of law theorists, there are some famous checklists, right? So there is, of course, Dicey's checklist of this, a list of the things that make the UK constitutional order a rule of law order. Yeah, there are also, of course, Lon Fuller's sort of list of desiderata of the rule of law, right? And so famously, he has the list of 8 that comes out in the parable of King Rex, right? The requirements that laws be general, public, prospective, clear, non-contradictory. There must be a possibility of compliance with them, right? And there must be consistency and what he calls congruency, right? So lists of what the rule of law requires. Yeah? And the Supreme Court of Canada also has set out a list of what the rule of law requires. So the Supreme Court of Canada says that the key features of the rule of law is that ordinary citizens and public officials are equally subject to the law. Right? All exercises of public power must find their source in law. And the rule of law requires a system of positive law. So lists, right? Conditions, criteria for assessing whether a legal order is compliant with the demands of the rule of law. So Walters juxtaposes these kinds of theories of the rule of law, these kind of what he calls the rule of law as yeah. So then, like, he juxtaposes against these sort of classificatory approaches to the theories of the rule of law with what he calls an interpretive approach to the rule of law, right? And he says, look, there other ways of thinking about the rule of law than to think of criteria or conditions necessary for the rule of law, right? And he gives examples of one example he gives is of Dworkin, right? And Dworkin famously in his theory of legal interpretation as integrity, right? Says, look, one of the reasons why we have these requirements of fit and justification, right? And these requirements of justification is that they evidence a kind of respect of the legal order for citizens, right? An equal respect and equal treatment of citizens within the legal order, right? So he famously juxtaposes or contrasts this idea of law's integrity with a checkerboard approach to law, right? So it's this idea that we are governed by principles applicable to all, general principles, expresses this respect for the equality of all who are subject to the law, right? And so through this process of interpretation, through this kind of interpretation, we give effect to the underlying normative commitments of the rule of law. Another example that that Walters gives in his this version of the rule of law is another Canadian, David Dysenhouse. I'm going to name all the Canadians tonight. There were not that many of us, and we all know each other, and they're all going to get shouted out today. Yeah, and so David Dysenhouse has also sort of given an interpretation of theory of the rule of law, in which he says, look, there's a difference between deference as respect, right, and deference as kind of submission, right? So under deference as respect, courts will defer to political actors if political actors can give reasons for their actions. And he's speaking in a particular context of administrative law, right? But as a kind of general principle, this idea that state action is justified when it can be supported by reasons, right? And it is only worthy of deference when it is supported by reasons, is different from a conception of deference that simply submits to the actions of political actors. So this is a kind of a methodological contribution that Canadians have made. Yeah. So the first contribution is this methodological, a division between approaches to the theoretical approaches to the rule of law, some focused on conditions or criteria, others focused on this kind of interpretive approach. The second the second kind of broad contribution I want to highlight today of Canadians to the rule of law is a kind of substantive conception of the rule of law. And this, so I'm going to highlight Stephen Toop's recent work on the rule of law. And I think one of the things that makes Toop really interesting is that he kind of reconciles these two approaches to the rule of law, right? So he says, look, yes, and he focuses on Fuller in his writing. Right? He says, look, the 8 desiderata are, of course, the kind of criteria for assessing whether a system is compliant with the law, right? But the reason why these things are important, why these items, these conditions are important, isn't sort of as a kind of checklist, right? But rather because they evince a kind of attitude, a kind of posture of respect for citizens who are subject to the exercise of power, right? So how does this work, right? The idea is that these desiderata, Fuller's desiderata, right, respect the ability of citizens subject to the law, right, to be able to interpret the law, to be able to contest the law, and to engage in self-directed action, to organize their affairs in light of the law, right? So the requirements of consistency are probably about the clearest example of this, right? The requirements of publicity, yeah. And so the kind of reconciliation of the rule of law that focuses on conditions and the rule of law which focuses on interpretation and giving effect to the values of the rule of law through interpretation is done, I argue, in Toop's approach, in a kind of reconciliation of the two, right? The desiderata aren't just like a checklist that are morally neutral, right? So Raz formerly said, look, famously said, look, the rule of law is like a knife. You put good ends into evil ends, right? And I think Toop disagrees with this. I think Toop's argument is that the rule of law serves moral ends, right? And the moral ends that it serves are this fundamental commitment to respect for citizens who are subject to the law. He calls this a relationship, drawing up Fuller, this relationship of reciprocity between the giver of law, those who exercise power, and those who are subject to the exercise of power through law. So that is, I think, a kind of substantive contribution to the rule of law. It's not sort of Stephen Toops alone. Kristen Rundle famously has given a version of this theory of the rule of law. But Kristen was at McGill around the same time Jeff and I were at McGill, and so I claim her as an honorary Canadian. So she is an honorary Canadian making contributions to the theory of the rule of law. Virtually. Yeah. And she went back too. So, so these are the theoretical contributions of Canadians to the rule of law. So what are the implications? What are some implications for of these theories of the rule of law? Well, I think one sort of key implication, or one implication that's drawn out, I don't think it's a necessary implication, is that it sort of expresses a view of the relation of the exercise of power within a political system, right? And so, Toop, Walters, Deisenhouse, Rundle, the kind of Canadian, right? All understand the exercise of power within a constitutional order as being conditioned by the requirements of the rule of law, right? And so why is this important, right? It's important because I think for a variety of reasons, but for those of you who are kind of steeped in theories of public law that make a clear distinction between constituent power and constituent power, right? Constitutive power, right? I think that these theorists kind of contest the idea of a constituent power that is exercised within a constitutional order, free of the requirements of the demands of legality. Yeah. And so Mark Walters famously has developed a kind of theory of legitimacy within constitutional law. And he says, look, the legitimacy of a constitutional order is not given by some external source, right? By popular sovereignty, by the will of the people, right? A constitutional order is legitimate, he says, right? Is legitimated through this exercise of interpretation. This exercise of always trying to interpret the law in ways that render it legitimate to those who are subject to authority. Okay. So much for Canadian theorists. Yeah. So these are the contributions, right? A kind of methodological contribution, a substantive contribution, and a kind of an implication of the rule of law, which takes a particular stance on the role of political power within a constitutional order. So let me turn now to some applications. So if you're sick of Canadians, I will now turn you over to like some issues in Canadian constitutional law. But I'll start with one that's a kind of like generally, right? So the emergency power, as I said at the very outset, and was met with like a big grimace, is sometimes understood as sort of exercised outside the constraints of the constitutional order, outside the constraints of the rule of law. Yeah, and for much of Canadian constitutional history, I think this is kind of how emergency powers were kind of understood. So under the predecessor legislation to the current Emergencies Act, right? Basically, the governing council, so cabinet, could declare a kind of war. It was called the War Measures Act. Could kind of declare a state of kind of emergency. Its declaration of the state of emergency would make it so, and then they could exercise essentially unbridled authority under that power. Yeah, that sounds like a kind of Schmittian situation within the constitutional order, right? The ability to exercise power outside the constraints of law, the requirements of the rule of law. So in Canada, right, there was legislation, and in Canadian history, there is some examples, some terrible things done under this power, right, including the internment of Japanese Canadians during World War II. Yeah. So the successor to the War Measures Act, the Emergencies Act, which this dates to 1988, cabins the emergency power, right? And it cabins it by giving actual criteria for the exercise of the emergency power, right? And so one of the sort of limits, the conditions for the exercise of the emergency power is under the so-called public order emergencies. So there are different kinds of emergencies under which the executive can act, right? And one is a public order emergency, right? So the legislation says that one of the conditions under which you can invoke this power is if there is a public order emergency. Now, the interesting thing here is, well, interesting to me and therefore like inflicted on you, is that the definition of a public order emergency is incorporated by reference from another piece of legislation. Right, so the Emergencies Act incorporates by reference the definition of what is a public order emergency from the Canadian Secret Intelligence Services Act, right? And the definition in that other act says that a public orders emergency arises if there is a threat of serious violation of personal or physical integrity or personal property, right? So the Emergencies Act for a long time was never invoked, right? But in 2022, right, during COVID, right, it was invoked because there were protests across Canada, right, including the so-called convoy protests, right? And so convoys of truckers rolled into Ottawa and were there for a while, right, disrupting everyday life in Ottawa. There were serious issues at the Canadian border, including situations in which arms were stockpiled, right? And so the government invoked the Emergencies Act, yeah? And in particular, it invoked the justification for the Emergencies Act under the public order. So they said there was a public order emergency. So it's kind of an interesting situation because we have this invocation of this power, which is somewhat kind of often understood as outside the requirements of the law, now placed within legislation, right? And placed within, arguably, right, the limits that of the rule of law imposes through the requirements of the rule of law when the rule of law is evidenced through legislation. So what does this mean concretely in this case, right? So the question that came up in litigation was whether or not the government, the executive, let's say, was justified in invoking the public orders emergency, right? And one of the reasons why this is controversial is because when the government offered its justification, right, and which it is required to do under the legislation, right, it did so. It said one of the things it mentioned was the serious threat to the Canadian economy posed by these protests, right? And so the federal court, in assessing this invocation of emergency power, said, look, that's not obviously justified, right, by appeal to this legislation, this definition in the Canadian Services and Secret Intelligence Services, right, Act, right? And so, at least to the extent that it relied on this public order emergency power and invoked it in relation to these economic matters, it was acting ultra vires. It was acting outside of the scope of its authority, right? So instead of the emergency power hovering out there in the world as something that is independent of the requirements of the rule of law, it is now subject to the requirements of law, right? And I think that Mark Walters has done a really good job of sort of reinterpreting Dicey. And one of the things that Walters says about Dicey is that Dicey's theory of Dicey's approach to parliamentary sovereignty is often presented as a kind of in opposition to the rule of law. And Walters says, no, if we understand Dicey correctly, right, the parliamentary sovereignty is subject to the requirements of the rule of law because it is through law that Parliament acts, right? Not through individuated commands, but rather through general rules, and by subjecting itself to the requirement, to this form of exercising political authority, through rules, general rules, that are then interpreted by courts. Parliament limits itself, it constrains itself by things that look like requirements that look like the theories, requirements of the theories of the law that we settled earlier, right? To this requirement of generality, Fuller's desiderata, to the requirements of justification, Walter's understanding of the rule of law as evincing a respect for the agency of individuals, equality of individuals through this exercise of interpretation. So that's one example, right? So the rule of law subjecting the emergency power subject to the requirements of the rule of law through its codification in legislation, and therefore being subject to the requirements of generality, right, and interpretation. And in so doing, right, placing those who are subject to the exercise of power in a position where they can call on those who exercise power to justify those exercise of power, even emergency powers, in ways that are respectful of the agency, those who are subject to that exercise of power. Okay, so I'll close with the notwithstanding clause. So for those of you who aren't all that familiar with the notwithstanding clause, it's an interesting quirk of the Canadian Constitution, right? And so section 33 of the Constitution says in a nutshell that laws can operate notwithstanding certain protections in the Charter of certain rights, right? When the notwithstanding clause is invoked, right? And when it's invoked, that the invocation lasts for 5 years and then it has to be renewed, okay? Or it drops away. So there is a kind of deep debate in Canadian constitutional law about what this clause actually is about. So on one version of the rule of law, you can think on one version of the interpretation of the notwithstanding clause, you can think of this as a pure exercise of parliamentary sovereignty. Or to take it slightly further, you can understand this to authorize a pure exercise of the constituent power, unbounded by any constitutional requirements, right? Other than requirements of form, right? So you have to say that you're invoking the notwithstanding clause, right? But aside from that, you don't have to pay any attention to the rights that are overridden, right? It is, in the language of the sort of emergency powers or Schmittian language, it is an exception to the constitutional order protection that which protects rights normally. Yeah. Now, juxtaposed to this is a theory of the notwithstanding clause, which says, look, no, the notwithstanding clause is just recognizing a kind of institutional pluralism. And it's related to, I think, some of Jeff's and Aaron's work on the ways in which constitutional interpretation in a constitutional order is not the monopoly of the courts. Yeah. So in this theory, this understanding of the notwithstanding clause, the exercise of the notwithstanding clause just evidence an alternative interpretation of the relevant rights. Yeah. So it's not operating outside of the constitutional order, it's within the requirements of this rights protecting order. Okay. So concretely, what does this mean? There's a kind of debate among the appellate courts, and now the question is going to the Supreme Court about whether or not a court can declare a legislation to be unconstitutional, right? To violate the Constitution because it violates the rights, right? Infringes rights without justification, right? Even though that declaration would have no effect, right? Because the invocation of the notwithstanding clause would allow that law to continue to operate for the duration of the applicability of the invocation. Right? So that's one view of the appellate courts, right? That yes, courts can declare that a law violates the Constitution, right? And you might say, well, why would you possibly do that? Like, who cares, right? That declaration would have no effect, right? And I think the reason why it's important is because it calls on the what we earlier described, what I earlier described as this interpretive approach to the rule of law, right? That is, by interpreting the Constitution, right, the courts and by calling on the government to defend its interpretation of the Constitution, right? It reasserts this kind of relationship of reciprocity between those who exercise power and those who are subject to power, right? There is an attempt to justify what, if you are a legislature and you've invoked the notwithstanding clause, you are under an obligation to justify your exercise of the notwithstanding clause. You're obliged to say, no, this is an alternative interpretation of rights. It is not flagrant disregard for rights. Yeah, and that has value in a rule of law system. And so juxtaposed against this is an understanding of the notwithstanding clause as unconstrained by this requirement of justification, as kind of outside these requirements of justification. And so ultimately, I think that the notwithstanding clause, this debate about the notwithstanding clause, can be understood in Stephen Toope's terms as a kind of debate about whether or not the exercise of the Constitution of the notwithstanding clause is subject to kind of the background conditions of the Constitution, right? And one of the background conditions of the Constitution is that we interpret exercises of power. We look at exercises of power and justify them using the standard tools of legal interpretation, right? And so Toope says, there's a style of argumentation that is like a background condition of a constitutional order. And when he talks about congruency, he says, look, when we think about congruency, it's not just the congruency between the acts of officials and what the law requires. It's congruency between the background values and practices of a constitutional order. And one of those background values and one of the background practices is this practice of interpretation and this requirement of justification, right? So we can see in the notwithstanding clause a kind of instantiation, or at least one position of the appellate courts of this interpretive understanding of the rule of law. So that's the rule of law in Canada, right? Approaches theoretical contributions to the literature on the rule of law, methodological, substantive, with implications for how power is exercised within a constitutional order. And two illustrations, right? In which there's a kind of debate about whether or not power exercised in a constitutional order is constrained by the demands of the rule of law, or is it independent of those demands? Look for your questions.
Thank you very much, Hoy, for that very, very lucid conversation. I want to presentation. I will stand here because I'll be managing the participation online. Before we begin general questions, could I ask you to clarify something about section 33?
Yeah.
That provides that the Parliament of Canadian or any provincial parliament can provide that a law shall stand notwithstanding the provisions of the charter, select provisions.
Yeah.
Is the debate about whether the court still has jurisdiction to issue a declaration that it violates the charter?
Yeah.
Notwithstanding the existence of a prophylactic section 33.
That's right. I think part of the question is whether it is actually prophylactic in that sense, right? Whether it essentially preempts
any judicial
right.
That's okay. So there's no question about that the court can enforce the charter.
Okay, so this gives rise to like a second piece of the debate, which is kind of related, but there is I think a question, and I've raised this question myself, whether or not there's certain kinds of invocations of the notwithstanding clause, right, which amount to essential amendments of the Canadian Constitution. Right. So you can imagine like an invocation of the notwithstanding clause, which has effects that are so grievous to, let's say, freedom of, so the example I've used is like freedom of religion, right? So imagine that you have like the state, a province enacts legislation that makes the holding of religious beliefs like mandatory, right? And there are penalties for not holding those beliefs and not engaging in those practices, right? And I think that like it's kind of flagrant disregard for the rights in section 2A. It's not operating notwithstanding, it's obliterating the right.
Okay.
And therefore it amounts to kind of an amendment. I think like it's similar to debates around common law constitutionalism, right?
And basic structure.
Right.
Some other
That's right.
jurisdictions. Okay, that is fascinating. Great. Please join me in thanking our